My daughter-in-law handed me a bill for living in my own house. The paper felt wrong in my hands. Official letterhead, my name typed under tenant, her name under landlord. $850 due by the 15th. A late fee of $75 after that. "This is your monthly housing contribution," she said, straightening the papers on my kitchen table. "We've discussed this. It's time to formalize our arrangement." I looked at the address printed at the top, my address. The house I'd paid off after decades of mortgage payments. The house where I'd raised my son, where his wife now sat like she owned the place. "I don't understand," I said. "This is my home." "Mom, things have changed," my son said from the doorway. He wouldn't meet my eyes. "We're all adults here. Everyone should contribute." I read the line again. Tenant Eleanor Hayes. Not mother, not homeowner. Tenant. The logo at the top was one I'd never seen before. Hayes Property Management. My last name, printed like a warning label. "You made a company?" I asked. "It's just for bookkeeping," she said. "Everything legal and proper. No more confusion about who pays what." My son stepped closer to his wife, a unified front against me, his mother, in my own kitchen. "We're trying to run a household efficiently," he said. "This makes it fair for everyone. Fair." I'd opened my door, I'd kept the lights on, and now I was being invoiced to exist in the house that still belonged to me on paper. I set the bill down carefully and smoothed it flat, like if I pressed hard enough, it would stop being real. That's when she slid a second page forward, the lease, and said, "Just sign here." It started innocently enough 2 years ago. My son called on a Tuesday evening. "Mom, Jessica and I need a place to stay for a few months, just until we get back on our feet." Her business hit some rough patches. I'd said yes immediately. What mother wouldn't? They moved in that weekend with 3 suitcases and promises it would be temporary. 6 months maximum, Jessica had said, standing in my living room with her hands on her hips, already surveying my furniture arrangements. The first month felt normal. They contributed to groceries. Jessica helped with some cleaning. My son mowed the lawn. I enjoyed the company after being alone for 5 years since my husband passed, but somewhere around month 3, Jessica's language began to shift. "Our electric bill is higher than expected," she'd say at dinner. "I reorganized our linen closet," she'd mention while folding towels. "We need to discuss our cable package," she'd announce during my evening news. Hour. She started calling my kitchen our kitchen. I noticed but didn't say anything. Family harmony mattered more than semantics. Or so I told myself while watching her rearrange my spice cabinet according to her preferences. By month 6, Jessica had established new household routines. Mail delivery went through her first. She'd sort through everything on the kitchen counter before bringing me what she deemed important. Bank statements, insurance notices, Social Security correspondence, all filtered through Jessica's review. "I'm just helping organize, Mom," my son explained when I asked about it. "Jess has a good head for paperwork." The temporary living situation stretched into year 1. Then Jessica announced they were staying indefinitely to help care for me as I aged. I was 72 and perfectly capable of caring for myself, but apparently that decision was no longer mine to make. She began changing locks. First the front door, then the back. Security upgrade, she called it. "Your old keys weren't very secure, Mom. These are much better." The new keys felt different in my hands, heavier, more complicated. But Jessica controlled the key distribution. I received 1 set, she kept 3. Then came the garage door code change. The old one was too simple. We upgraded to something more sophisticated. I needed permission to use my own garage. When I asked for the new code, Jessica would sigh as if I was being difficult. "You're going somewhere. Do you need me to drive you? You know night driving isn't recommended for people your age. People my age, as if 72 meant incompetent. I'd driven safely for 56 years, but suddenly my ability was questionable, according to my daughter-in-law, who'd been living in my house for 14 months. The gradual takeover accelerated during year 2. Jessica introduced household meetings, mandatory attendance every Sunday after church. We need better communication about household responsibilities, she'd say, armed with printed agendas and color-coded charts. These meetings covered everything from thermostat settings to grocery shopping schedules to television time allotments. My preferences became suggestions to be voted on by the 3-person household committee. I was outvoted 2-1 on most decisions. When I questioned the new arrangement, Jessica's tone shifted into patient explanation mode. Eleanor, we're just modernizing how the household functions. It's more efficient this way. Safety protocols are important for everyone. She talked to me the way teachers address slow children. These systems work in many multi-generational households. I researched best practices online. My son stood beside his wife during these conversations, nodding along with her explanations as if I needed their permission to live in my own home. She looked at me like I was a confused child. The research apparently included financial oversight recommendations. Jessica began requesting access to my bank statements for household budgeting purposes. If we're sharing utilities and expenses, we should coordinate our financial planning, she explained during one Sunday meeting. I have experience with business accounting. Her failed business experience, I wanted to remind her, but kept quiet. Jessica produced spreadsheets showing household expenses broken down by usage patterns. According to her calculations, I was using 60% of the electricity, 55% of the water, and 40% of the heating costs despite being one of 3 residents. It's only fair that expenses match usage, she concluded. My son reviewed her spreadsheets and agreed with her assessment. Mom, you do run the heat higher than necessary, and you leave lights on in empty rooms. Empty rooms. In my own house. I tried to assert my position as the homeowner. I mentioned that I'd been paying all household expenses before they moved in. I pointed out that the mortgage was paid off and the house belonged to me. Of course it's your house, Eleanor, Jessica said smoothly. We're not questioning ownership. We're just discussing fair contribution to ongoing household maintenance costs. She made it sound reasonable, logical even. Everyone should contribute according to their ability and usage. That's how successful households function. My son nodded along, as if his mother charging him rent was a natural order of things. Jessica's contribution concept evolved into specific dollar amounts. First, she calculated my share of utilities based on her usage analysis. $78 monthly for electricity, $42 for water and sewer, $36 for trash and recycling. Then came my portion of groceries, household supplies, lawn maintenance, and home repairs. Suddenly, I was contributing to my own utilities. The word contributing made it sound voluntary, generous even, like I was helping out rather than being charged to live in my own home. Jessica provided detailed invoices each month, professional-looking statements with line items and calculations. She'd present them during our household meetings, with charts showing how my contributions compared to my usage patterns. This month, Eleanor's contribution is $234, she'd announce, as if reporting to a board of directors. My son would review the numbers and approve the assessment. I was being charged administrative fees for the privilege of being managed by my daughter-in-law in my own house. The monthly contribution system worked smoothly for Jessica's purposes for about 8 months. Then she announced we needed to formalize our arrangement with proper documentation. Eleanor, I've been thinking about our household structure. We need legal clarity about everyone's roles and responsibilities. She produced a manila folder thick with papers, legal-sized forms with dense text and signature lines highlighted in yellow. The documents looked official, professional, like something from a real estate office or attorney's practice. "What is this?" I asked. "It's a residential lease agreement, for clarity, so everyone knows exactly where they stand legally." I flipped through the pages. Landlord signature line, tenant signature line, monthly rent amount, security deposit requirements, rules and regulations, termination procedures. The papers already had my name in the tenant line. "Jessica, this is my house. I own this house. I don't need to lease my own home." "Of course you own it, Eleanor. This doesn't change ownership. It just formalizes our living arrangement. Think of it as a roommate agreement, very common in multi-generational households." She pointed to sections about household duties, guest policies, and noise restrictions as if these were reasonable topics to regulate between a mother and her adult children. My research shows that clear documentation prevents family conflicts. It protects everyone's interests. My son appeared in the kitchen doorway, holding a coffee cup and car keys. "What's going on?" "I'm explaining the lease agreement to your mother," Jessica said. "She has some questions." "Mom, we talked about this. You agreed we needed better structure." I had no memory of agreeing to sign a lease for my own home. "When did I agree to this?" "Last month during our household meeting, when we discussed long-term planning. I remembered a conversation about household efficiency. I didn't remember agreeing to become a tenant in my own house. This seems like a lot of paperwork for a living arrangement." "It's standard, Mom. Jessica researched this thoroughly. It protects everyone." He said Mom just needs to adapt to new arrangements. Jessica spread the documents across my kitchen table, pointing to signature lines and initial requirements. "I've marked everything you need to sign. It's mostly formalities. The terms are very reasonable, much more flexible than typical landlord-tenant relationships." She explained that the lease would be month to month, renewable automatically unless either party gave 30 days notice. The rent would be $850, due by the 15th of each month. Late fees would apply after 3 days. "I don't understand why we need all this. Can't we continue the way we've been doing things?" "Eleanor, informal arrangements create confusion. This way, everyone knows exactly what's expected. No misunderstandings, no family drama." "What happens if I don't sign?" Jessica and my son exchanged glances. "Well, we'd need to reconsider our living situation," Jessica said carefully. "This arrangement has to work for everyone. If it becomes too complicated or stressful, we might need to explore other options." "Other options, like them moving out, like me losing my family." "I need time to think about this." "Of course, take the evening. We can finalize everything tomorrow." She gathered the papers into a neat stack and placed them beside my evening medications. "There's really nothing to worry about, Eleanor. It's just paperwork." The next day, Jessica returned with the documents and a notary public, a woman in a business suit with an official seal and identification. "I thought we could handle everything today and get it out of the way," Jessica explained. "I haven't had time to read everything thoroughly. I can walk you through the important sections. Most of it is standard language required by law." Jessica guided me through the signature process quickly. "Page 7, initial here. Page 12, sign there. Page 15, date and print your name." The notary checked my identification and recorded the signing in her journal. "You're all set," she said, packing her seal and papers into a briefcase. Jessica handed me a copy of the completed lease agreement. "Your copy for your records," she said. I noticed immediately that my copy had different page numbers than the documents I'd signed. Page 7 was missing, Page 12 contained different language than what Jessica had explained. The papers already had my name in the tenant line. Something was wrong with the numbering, with the content. But the notary was already leaving, and Jessica was cleaning up the kitchen table as if the business was finished. "I think some of these pages are different," I said. "Different how?" "The page numbers don't match what I signed." "Oh, the notary must have reorganized them when she made the copies. Standard procedure. All the important information is there." My son reviewed the copy and confirmed that everything looked correct. "See, Mom? Nothing to worry about. Just paperwork." I signed where she pointed, trusting family. The lease went into effect immediately. Jessica announced the new household policies the following Monday during our regular meeting. Now that we have proper documentation, we can implement some additional structure for everyone's benefit. The first change involved guest policies. According to the lease terms, I needed to provide 24 hours advance notice for any visitors. Overnight guests required written approval from the property manager. Property manager, Jessica. "This is just for security and planning purposes," she explained. "So we know who's coming and going. My sister had been visiting every Thursday afternoon for tea and conversation for the past 18 months. Now I needed permission slips for family visits." "What about my doctor appointments?" "You can schedule those anytime, of course. Just let me know so I can coordinate household schedules." Coordinate household schedules for my medical appointments in my own house. The second change involved common area usage. Living room television time would be allocated by household meetings. Kitchen usage required advanced scheduling for large meal preparations. Laundry needed to be coordinated through a shared calendar system. This prevents conflicts and ensures everyone gets fair access to shared spaces, Jessica explained. Shared spaces. My living room was now a shared space requiring permission to watch my evening news programs. The third change covered financial procedures. Rent payments would be processed through a new system. Online payments preferred. Late fees calculated automatically. Security deposits held in a separate account for property maintenance reserves. Very professional, very clean, no confusion about money matters. Jessica had created rental contracts, payment schedules, and property management protocols for my own house. My home had visiting hours. The lease specified quiet hours from 10 p.m. to 7 a.m. No music, television, or conversation above normal speaking volume during designated rest periods. I'd been watching late-night news in my living room for 43 years. Now, I needed headphones after 10 o'clock to avoid violating my lease agreement. "It's really for everyone's consideration," Jessica said when I questioned the noise restrictions. Multi-generational households require extra thoughtfulness about sharing space. My son agreed that the quiet hours made sense for household harmony. The first rent payment was due in 12 days, $850 payable to Hayes Property Management. Jessica provided payment instructions, check, money order, or electronic transfer to the business account she'd established. "Much more professional than our informal arrangement," she said. "Better record keeping for everyone." I was paying rent to live in the house I'd owned for 43 years. To the daughter-in-law who'd moved in temporarily 2 years ago and never left. The lease made it official. I was now a tenant in my own home. The first rent payment was due in 15 days, but something bothered me about the entire arrangement. Real landlords didn't live in the same house as their tenants. Real tenants had legal protections. I decided to educate myself about my supposed rights. I waited until Jessica and my son were both out running errands before opening my laptop. Searching tenant rights felt strange when sitting in my own living room, but I needed to understand what I'd agreed to. The results were eye-opening. According to state law, residential tenants had specific protections. Landlords couldn't enter rental units without proper notice. Tenants couldn't be evicted without cause and due process. Lease agreements required specific disclosures and formatting to be legally binding. Security deposits had to be held in separate accounts and returned within 30 days of lease termination. Late fees couldn't exceed certain percentages of monthly rent. Rent increases required advance notice and couldn't be imposed arbitrarily. I compared these requirements to my lease agreement. Jessica's version included none of the mandatory disclosures, no lead paint warnings, no contact information for regulatory agencies, no security deposit procedures that matched legal requirements. Real tenants have more protections than me. Most disturbing was the section about landlord qualifications. Property management required business licenses in our city. Rental income had tax implications. Professional landlords carried liability insurance and followed housing code regulations. Jessica's Hayes Property Management appeared nowhere in city business registrations. I checked online databases for licensed property management companies. No matches. Her business seemed to exist only on my lease agreement and the invoices she generated on her home computer. Meanwhile, I began documenting everything. I'd kept a household calendar for decades, marking important dates and appointments. Now I started recording conversations, noting exact times and Jessica's specific words about household policies. I photographed my copy of the lease agreement and compared it to the original documents I remembered signing. Page 7 was definitely missing from my copy. Page 12 contained completely different language about termination procedures. Page 15 had an extra paragraph about property manager authority that I didn't recall reviewing with Jessica. The page numbers in my lease copy didn't match what the notary had recorded in her official journal. My copy had different terms than theirs. I started keeping detailed financial records as well. Jessica's monthly invoices for my contribution had been informal compared to the professional rent collection system she'd introduced with the lease. Now, I had official payment coupons and account numbers. I saved every payment coupon, invoice, and receipt. I documented late fee calculations and compared them to legal limits. Jessica's $75 late fee exceeded the 5% maximum allowed by state law for residential rentals. Jessica was charging illegal late fees according to tenant protection statutes. I also researched property management authority. Legitimate property managers operated under written agreements with property owners that specified their responsibilities and compensation. Jessica had never presented any such agreement. She'd simply declared herself the manager of my property without my explicit authorization. The more I learned about tenant law, the more convinced I became that Jessica's lease arrangement violated multiple legal requirements. But I needed to test my suspicions carefully. The opportunity came when Jessica presented me with an unexpected charge on my monthly statement, a late fee for the previous month's utilities contribution, even though I'd paid on time. "Eleanor, there's a processing delay fee for your utility payment last month. It was submitted after the 10th, so there's an additional $25. I checked my records. I'd paid on the 8th, well within the 10-day window she'd established. I paid on the 8th. Here's my check copy. Yes, but it wasn't received until the 11th. That creates administrative complications. Administrative complications. For a check handed directly to her in my own kitchen. This seems like a mistake. I gave you the payment in person." Jessica's expression hardened. "Eleanor, the lease is very clear about payment deadlines and processing procedures. Late fees apply when payments aren't received timely, regardless of circumstances. I'm not paying a late fee for a payment I made on time." "Then we have a problem. Unpaid fees constitute lease violations. She produced a formal notice printed on Hayes' property management letterhead, a demand for payment with legal language about default remedies and termination procedures. She waived legal papers about non-payment. The notice gave me 5 days to pay all outstanding charges or face eviction proceedings. Eviction from my own house. If you're listening and your stomach just tightened the way mine did, please share this with someone who has an older parent. I used to think family meant I was safe. That was my first mistake, because in their eyes, I wasn't a mother anymore. I was a tenant who'd stepped out of line for disputing a $25 fee on a payment I'd made correctly and on time. That evening, I made a decision that would change everything. I called the elder law attorney whose advertisement I'd seen in the local newspaper, a small practice specializing in senior legal issues, estate planning, healthcare directives, and elder abuse prevention. The receptionist scheduled a consultation for the following Tuesday morning, while Jessica and my son would be out shopping. I told her I needed to discuss a residential lease agreement that might have legal problems. "Can you bring all related documents? The attorney will want to review everything." I gathered my lease copy, payment records, Jessica's invoices, and notes about our conversations. I also printed information about state tenant protection laws and property management licensing requirements. Tuesday morning arrived gray and rainy. Perfect weather for a clandestine meeting with an attorney to discuss my own living situation. The irony wasn't lost on me. The law office was small and professional, clean but not fancy, the kind of place that specialized in helping real people with real problems rather than corporate legal matters. Attorney David McKenna reviewed my documents for 20 minutes without speaking. He made notes on a legal pad and occasionally asked clarifying questions about dates and Jessica's specific statements. "Mrs. Hayes, how long have you owned your home?" 43 years. It's been paid off for 3 years. "And your daughter-in-law moved in when?" 2 years ago, temporarily, supposedly. "Has she ever paid rent to you?" "No, she's been living there for free until she decided I should pay her." He flipped through the lease agreement again, focusing on the signature pages and notary section. "This document has several problems, significant problems." He explained that property managers needed written authorization from property owners. Jessica had no legal authority to act as my landlord. The lease itself violated numerous state requirements for residential rental agreements. More importantly, this appears to be financial exploitation of a senior citizen. That's both a civil matter and a potential criminal offense. Financial exploitation. I hadn't thought of Jessica's arrangement in criminal terms. What does that mean exactly? It means someone in a position of trust is taking financial advantage of you through deception or coercion. In your case, someone living in your home rent-free has convinced you to pay them rent through fraudulent documentation. He pointed to specific problems with the lease: improper notarization, missing required disclosures, illegal fee structures, and unauthorized property management claims. "Mrs. Hayes, you're not actually a tenant. This lease agreement is likely invalid and potentially fraudulent. The real question is what you want to do about it." He said 3 words. "We've got them." The consultation fee was $200, but the information was invaluable. Jessica's entire rental scheme violated elder abuse laws, tenant protection statutes, and business licensing requirements. For the first time in months, I felt like I had options beyond paying rent to live in my own home. Attorney McKenna asked me to return the following week with every document related to Jessica's property management scheme. He wanted bank statements, payment records, correspondence, and anything else that showed the pattern of financial control. "We need to build a comprehensive timeline of exploitation," he explained. Financial abuse cases require detailed documentation to prove systematic behavior rather than isolated incidents. I spent the week organizing 2 years of evidence I hadn't realized I was collecting. Bank statements showing Jessica's deposits from my contributions. Email exchanges about household policies. Handwritten notes from our Sunday meetings. Photographs of posted rules and regulations around my house. The second consultation lasted 3 hours. McKenna reviewed everything methodically, making notes and asking specific questions about Jessica's statements and my responses. He started with the lease agreement itself. Mrs. Hayes, look at the notary section on page 15. What date did you sign this document? October 3rd, Tuesday afternoon. The notary stamp shows October 2nd, Monday. I examined the signature page more carefully. The notary's official seal was dated 24 hours before our meeting. The journal entry number didn't match the stamp impression. The notary's signature looked different from her identification card, which I remembered checking during our kitchen table signing. The notary's signature was dated wrong. McKenna explained that improper notarization invalidated legal documents. Backdating notary acknowledgments was a criminal offense. Jessica's rush to formalize our arrangement had created multiple procedural violations that undermined the entire lease agreement. But there's more, he said, flipping to earlier pages. Look at the property descriptions section. The lease described my property as residential rental unit managed by Hayes Property Management under authorization from property owner. But no such authorization existed. Jessica had never requested permission to manage my property. She'd simply declared herself my landlord and created documents to support her claim. She's essentially forged property management authority, McKenna explained. That's fraudulent documentation of business relationships. We moved to financial records. McKenna wanted to see every payment I'd made to Jessica over the past 18 months, from informal contributions to official rent payments. I'd brought bank statements, canceled checks, and screenshots from electronic payments. The pattern was clear and disturbing. For the first year, my payments had been reasonable contributions to shared household expenses, $50 to $75 monthly for utilities and groceries. Payments made to Jessica personally or split between household members. But once the lease was signed, payment amounts doubled and payment methods changed. All money now went to Hayes Property Management through business account transfers. Jessica's personal finances and property management income were apparently separate operations, even though she was the sole employee of both. Look at the memo lines on your payment records, McKenna said. Every transaction showed I was paying them. The electronic transfer records were particularly revealing. My October rent payment memo line read Tenant 1 monthly rent. My November payment showed Unit A occupancy fee. December was labeled residential lease payment. Jessica had created an entire property management business around charging me rent to live in my own house. The memo line suggested she managed multiple units and tenants, but I was apparently her only customer. McKenna also found problems with Jessica's financial procedures. Property managers were required to maintain separate accounts for security deposits, rent collection, and business expenses. Jessica's bank account mixed rental income with personal spending on restaurants, shopping, and car payments. She's treating your rent payments as personal income rather than property management revenue. That's both tax evasion and breach of fiduciary responsibility. The evidence was overwhelming, but McKenna wanted to understand Jessica's current behavior before determining our legal strategy. Has she made any recent demands or threats? I told him about the late fee dispute and eviction notice, Jessica's escalation from informal household management to formal legal threats suggested she was planning to use the lease agreement for more than rent collection. Mrs. Hayes, I believe your daughter-in-law is testing the boundaries of her authority. The eviction threat isn't really about $25. She's establishing precedent for exercising landlord powers over your living situation. McKenna explained that Jessica's ultimate goal might be gaining control of my property through legal manipulation. The lease agreement was step one. Eviction threats and financial pressure could lead to forced guardianship proceedings if I couldn't maintain my housing independently. This isn't just about money, it's about control. She's systematically undermining your autonomy as a property owner and independent adult. The legal implications were serious. Elder financial exploitation carried both civil and criminal penalties. Fraudulent business practices could result in prosecution and restitution orders. Document fraud added additional criminal charges. But McKenna also explained my options for resolution. We can pursue this several ways. Civil litigation for financial restitution and injunctive relief, criminal referral to Adult Protective Services and District Attorney, or private resolution through demand letters and negotiated settlement. What do you recommend? Given the systematic nature of the exploitation and fraudulent documentation, I recommend immediate court intervention. We'll file a petition for declaratory relief and temporary restraining order. He outlined the legal strategy. First, petition the court to declare Jessica's lease agreement void and unenforceable due to fraud and procedural violations. Second, request temporary restraining order preventing further collection attempts and eviction threats. Third, demand restitution of all rent payments made under the invalid lease. The goal is to stop the exploitation immediately and restore your rightful position as sole owner and resident of your property. McKenna estimated the process would take 6 to 8 weeks from filing to final hearing. Jessica would receive formal notice of the lawsuit and have opportunities to respond through her own attorney. She'll likely claim the lease arrangement was voluntary and beneficial. Our evidence shows otherwise. The filing fees would cost $450. Legal representation would be billed at $200 per hour. Estimated total of $3,000 to $5,000 depending on Jessica's response. Mrs. Hayes, I want you to understand that family litigation is emotionally difficult. Your relationship with your son and daughter-in-law will be permanently changed by this process. I'd been thinking about that inevitability since discovering the extent of Jessica's manipulation. Attorney McKenna, I've already lost my family. My son chose his wife over his mother when he supported, charging me rent to live in my own home. This legal action isn't destroying our relationship. It's acknowledging that Jessica already destroyed it. McKenna nodded and made notes about my emotional state for his case file. One more question. What outcome do you want from this process? Just stopping the rent collection or full accountability for financial exploitation? I thought about the past 2 years. The gradual loss of autonomy in my own home, the systematic erosion of my dignity and independence, the transformation from beloved mother to inconvenient tenant. Jessica had taken advantage of my love for my family to exploit me financially and emotionally. She'd used my desire to maintain family relationships to extract money and control from me through fraud and manipulation. The legal system existed to protect people like me from people like Jessica. I want everything stopped. The rent collection, the property management claims, the eviction threats, all of it. I want my house back. I want my independence back. I want her to understand that exploiting elderly family members has real consequences. McKenna reviewed the timeline for court filing. He could have the petition and restraining order request prepared within 48 hours. Service of process would happen within a week of filing. Mrs. Hayes, once we file these papers, there's no going back to informal family arrangements. Jessica will know you've taken legal action against her. Your son will have to choose sides publicly. I understand. Are you prepared for that level of family conflict? I'd spent months being treated like a confused elderly woman who didn't understand modern household management. I'd paid rent to live in my own home while being told it was for my own benefit. I'd been threatened with eviction by someone living rent-free in my house. The time for preserving family peace had passed when Jessica decided to exploit my maternal love for financial gain. File it. I want my house back. McKenna filed the petition and restraining order request on Thursday morning. Court filing fees, service of process charges, and initial legal costs totaled $827. The most expensive money I'd ever spent, and the most worthwhile. The legal documents were comprehensive, 22 pages detailing Jessica's exploitation scheme, fraudulent lease agreement, improper notarization, and unauthorized property management claims. Every violation supported by bank records, payment histories, and documentation of her systematic financial manipulation. The petition requested immediate relief, declare the lease void and unenforceable, prohibit further rent collection attempts, prevent eviction threats or lockout procedures, and order restitution of all payments made under the fraudulent agreement. A process server would deliver the papers to Jessica within 72 hours. Professional service at my home address, where she'd been living rent-free for 2 years while collecting rent from me. The irony was perfect. Friday afternoon, I was reading in my living room when the doorbell rang. Jessica answered, as she'd been doing for months as my self-appointed household manager. I heard unfamiliar voices in the hallway, followed by Jessica's surprised tone. "I'm sorry, what is this about?" Legal documents for Jessica Hayes regarding property management and residential lease matters. I need to confirm your identity and provide official service. Property management? I don't understand. The process server explained that Jessica was being served with a civil complaint filed in county court. She needed to review the documents carefully and respond through legal counsel within the time frame specified. Respond to what? What legal matter? Ma'am, the details are in the court papers. You'll need to read through everything and consult with an attorney about your legal obligations. I heard papers rustling, then silence. This says, "This is from Eleanor Hayes, my mother-in-law." "Yes, ma'am. Please sign here confirming receipt of service." More silence, then Jessica's voice, smaller and confused. "She's suing me." "I can't provide legal advice, ma'am. You'll want to review the documents with a qualified attorney." The front door closed. Jessica's footsteps moved quickly toward the kitchen, then back to the living room, where I was sitting. "Eleanor, I just received some very confusing legal papers." "Oh, what about?" Jessica held up the court documents, her face flushed and her voice tight with controlled panic. "These papers say you're claiming our lease agreement is fraudulent, that I've been financially exploiting you. Have you? Of course not. Everything we've done has been completely legal and transparent. You agreed to all our arrangements." I set down my book and looked at Jessica directly for the first time in months, without the careful deference she'd trained me to show. "Jessica, did you have legal authority to create a property management business using my home?" We discussed household management. You wanted better organization." "Did you have my written permission to act as my landlord?" "Eleanor, you're taking this too seriously. These are just family arrangements. Why are you involving lawyers?" Her confident facade had completely disappeared. The woman who'd spent 2 years lecturing me about proper household procedures and legal documentation was suddenly confused by actual legal procedures. "The papers say you could be charged with elder financial exploitation. What does that even mean?" I explained that elder financial exploitation was a criminal offense involving systematic theft from senior citizens by people in positions of trust. Family members who manipulated elderly relatives for financial gain faced both civil liability and potential prosecution. That's ridiculous. I've never stolen anything from you. I've been helping you manage your household more efficiently. By charging me rent to live in my own house? That wasn't rent. It was fair contribution to household expenses. Then why did you call yourself my landlord? Why did you create a lease agreement with eviction procedures? Jessica fumbled through the court papers looking for language that supported her position. These legal documents are full of technical language and legal jargon. They're twisting our family arrangement into something it never was. Jessica, did you or did you not present me with an eviction notice over a $25 dispute? It was procedure to clarify payment expectations. Procedure for what? Kicking me out of my own house? She called me asking about lawyers and courts. The conversation continued for 20 minutes. Jessica alternated between defending her actions as reasonable household management and claiming the legal papers misrepresented our family arrangements. She suggested we resolve everything privately without involving courts and attorneys. Family matters should stay within families. Legal action would destroy our relationships and create unnecessary expenses for everyone. Eleanor, I'm sure we can work this out. Maybe we just need to adjust our agreement, make it more comfortable for you. What agreement? The one where I pay you rent or the one where you threaten to evict me? Neither. We can go back to informal arrangements, like before the lease. You mean back to when you were living here, rent-free while I paid all household expenses? Jessica offered various compromises. No more rent payments. No more formal lease agreement. No more property management procedures. Just a return to casual family living arrangements with better communication and mutual respect. We can tear up the lease right now if that would make you feel better. Jessica, you can't tear up a court case. These aren't just papers between us anymore. This is a legal matter involving elder abuse allegations and business fraud claims. Elder abuse? Eleanor, I've never abused anyone. I've been taking care of you. By taking my money through fraudulent documentation? It wasn't fraudulent. It was legitimate household expense sharing. Then why did the notary backdate the signatures? Why did my lease copy have different pages than what I signed? Why did you create a fake property management company? Jessica had no answers for the specific legal violations detailed in McKenna's court filing. She kept returning to her central defense. Everything had been voluntary family arrangements designed to help me manage my household more effectively. Eleanor, you're 74 years old. You needed help with organization and financial management. I was providing assistance. I needed assistance becoming a tenant in my own home. That was just paperwork, documentation for clarity. Documentation for what? Evicting me if I didn't pay enough money? The conversation reached its conclusion when Jessica asked what I wanted to make this legal action disappear. What would it take to resolve this privately? What do you need me to do? Jessica, I need you to understand something fundamental. You don't get to negotiate the terms of exploiting me. You don't get to offer compromises about how much you'll steal from me going forward. I never stole anything. You've been collecting rent for a house you don't own from a woman you've been living with rent-free for 2 years. What would you call that? I'd call it fair contribution to household management. And I'd call it financial exploitation of an elderly family member. Jessica tried one final approach. She suggested involving my son in the resolution discussions. As her husband and my child, he could mediate a family solution that avoided court proceedings. Maybe we should wait for David to come home. He can help us work through this misunderstanding. There's no misunderstanding, Jessica. You created fraudulent documents to collect money from me illegally. That's not a family disagreement. That's a crime. You're being very unreasonable about this. Jessica, let me explain something about property ownership. Tenants don't get to decide what's reasonable for landlords, and you're not my landlord. But the lease agreement says, the lease agreement is void. Fraudulent documents don't create legal authority. She stared at me as if seeing me clearly for the first time since moving into my house. So what happens now? Now you respond to the court petition through your own attorney within the time specified, and you stop collecting rent from me immediately. And if I don't, then you'll face additional legal consequences for violating court orders. Jessica walked away toward her bedroom, carrying the court papers and her phone. 20 minutes later, I heard her talking loudly to someone, presumably my son, explaining that I'd hired lawyers and was claiming she'd committed crimes. Her voice carried through the house as she described the court documents and asked for advice about legal representation. The conversation lasted over an hour. I heard references to misunderstanding, family conflict, and legal technicalities. Jessica was spinning the situation as an elderly woman overreacting to normal family arrangements. But court documents don't lie. Evidence doesn't care about family relationships. Legal proceedings focus on facts rather than emotional manipulation. I told her tenants don't own the deed. By evening, the household atmosphere had changed completely. Jessica avoided eye contact during dinner and spoke only when directly addressed. My son appeared confused and concerned but unwilling to challenge his wife's version of events publicly. The legal papers had shifted the power dynamic in my own home. For the first time in 2 years, Jessica seemed uncertain about her authority over my living situation. The court had given me something I'd lost, the presumption that this was my house and I had rights within it. The court hearing was scheduled for 3 weeks after Jessica received the legal papers. She'd hired an attorney from a downtown firm specializing in family law and civil disputes. Her lawyer filed a response denying all allegations and claiming the lease arrangement was a voluntary family agreement designed to help an elderly woman manage her household expenses. Jessica's legal strategy portrayed me as a confused senior citizen who'd requested assistance with financial organization and now regretted the structure she'd helped create. Her attorney argued that family members living together commonly formalize expense-sharing arrangements, and that no exploitation had occurred. The courthouse was smaller than I'd expected. Clean and professional, but not intimidating. McKenna met me in the hallway 30 minutes before our scheduled hearing time to review our presentation strategy one final time. Mrs. Hayes, remember that judges deal with financial exploitation cases regularly. They understand the patterns and recognize the warning signs. Our evidence speaks for itself. What should I expect from Jessica's attorney? They'll try to characterize this as a family misunderstanding rather than systematic exploitation. They'll emphasize your apparent cooperation with the arrangement and suggest you understood what you were agreeing to. But I didn't understand. That's the point. Exactly. And our documentation proves the systematic deception that prevented you from understanding the true nature of what you were signing. We entered the courtroom at 9:45. Jessica sat at the opposite table with her attorney, both of them reviewing legal briefs and highlighted documents. She looked nervous but determined, dressed professionally in a business suit I'd never seen before. My son sat in the gallery behind Jessica's table. He nodded politely when our eyes met, but didn't approach to speak with me. The legal action had forced him to choose sides publicly, and his choice was clear. Judge Patricia Williams called the case at 10:15. An experienced family court judge with 20 years of experience in elder law matters, according to McKenna's research. This is a petition for declaratory relief and restitution in the matter of Eleanor Hayes versus Jessica Hayes, filed under Elder Protection Statutes. Mr. McKenna, please proceed with your client's case. McKenna presented our evidence methodically. The timeline of Jessica's gradual takeover of household management, the transformation from temporary house guest to self-appointed property manager, the creation of fraudulent business documentation to justify rent collection. Your Honor, this case represents systematic financial exploitation of a 74-year-old property owner by a family member in a position of trust. Mrs. Eleanor Hayes owns her home outright. She provided free housing to her son and daughter-in-law for 2 years. In return, the defendant manipulated Mrs. Hayes into believing she needed to pay rent to continue living in her own house. The judge reviewed our exhibits carefully. Bank records showing the progression from small household contributions to formal rent payments. The lease agreement with its multiple legal violations and procedural irregularities. Documentation of Jessica's unauthorized property management claims. Mr. McKenna, what specific violations are you alleging regarding the lease documentation? Your Honor, the lease agreement contains numerous procedural violations that render it void and unenforceable. Improper notarization with backdated acknowledgments. Missing required disclosures for residential rental agreements. Unauthorized property management authority claims. And financial terms that violate state landlord-tenant law. Judge Williams examined the notary section of the lease agreement, comparing the signature dates to the notary's official journal entries that McKenna had subpoenaed. The notary acknowledgement is dated October 2nd, but Mrs. Hayes's testimony indicates the signing occurred October 3rd. Can you explain this discrepancy? Your Honor, the defendant arranged for notarization before the actual signing meeting. This procedural violation invalidates the document's legal enforceability and suggests intentional misrepresentation of the signing process. What about the property management authority claims? The defendant has no written authorization from the property owner to act as property manager. She created a fictional business entity and assumed landlord authority without legal basis. This constitutes fraud in the creation of business relationships. Jessica's attorney presented their defense. He argued that family members commonly create formal agreements for expense sharing and that Mrs. Hayes had been an active participant in establishing the household management structure. Your Honor, my client moved into Mrs. Hayes's home at her invitation to provide companionship and assistance. Over time, they developed a system for sharing household expenses that worked well for everyone involved. Mrs. Hayes understood and approved all financial arrangements. Does your client have property management licensing required for residential rental businesses? Your Honor, this wasn't a commercial rental business. This was a family expense-sharing arrangement with documentation for clarity. Then why does the documentation create landlord-tenant legal relationships with eviction procedures? Jessica's attorney struggled to explain the contradiction between claiming family expense sharing and creating formal lease agreements with termination procedures. Judge Williams asked Jessica to testify directly about her property management claims and business licensing. Ms. Hayes, did you obtain business licensing for Hayes Property Management as required by city regulation? Why? No, Your Honor, it wasn't really a business. It was just for organization. But you collected rent payments made payable to Hayes Property Management business accounts? Yes, but that was just for bookkeeping clarity. And you issued eviction notices using Hayes Property Management letterhead? That was That was just to formalize communication about payment expectations. Miss Hayes, you can't simultaneously claim this was informal family expense sharing and formal business property management. Which was it? Jessica had no coherent answer. Her defense unraveled as Judge Williams pressed for explanations about the systematic business procedures she'd created around charging rent to her mother-in-law. Her lease unraveled in 10 minutes. Miss Hayes, did Mrs. Eleanor Hayes ever request to become a tenant in her own home? Not specifically, but she wanted help with household organization. Did she ask you to create a property management business? No, but I thought it would help with structure. Did she authorize you to act as her landlord with eviction authority? We discussed household responsibilities. That's not what I asked. Did she specifically authorize landlord-tenant legal relationship with eviction procedures? No, Your Honor. Judge Williams reviewed the financial evidence. Bank statements showing Jessica's personal use of rent payments collected from Mrs. Hayes. The mixing of residential lease income with personal expenses in violation of property management regulations. Miss Hayes, where did the rent money go that you collected from Mrs. Hayes? Into our household budget for shared expenses, including restaurant meals and personal shopping that don't appear related to property management? Some of it, yes. So you treated Mrs. Hayes's rent payments as personal income rather than property management revenue? I guess so, yes. The judge's final questions focused on Jessica's ultimate intentions for the lease arrangement. Miss Hayes, what was your long-term plan for this landlord-tenant relationship with Mrs. Hayes? I wanted to help her manage her household more efficiently by charging her rent to live in her own house, by creating structure and shared responsibility. And if she couldn't pay rent or violated lease terms, we would have worked something out. But your lease agreement includes eviction procedures. Were you prepared to evict Mrs. Hayes from her own home? Jessica had no answer. Judge Williams recessed for lunch and returned with her ruling at 2:30 that afternoon. This court finds that the defendant systematically exploited the plaintiff through fraudulent business documentation and unauthorized property management claims. The lease agreement is void and unenforceable due to procedural violations, lack of authority, and violations of elder protection statutes. The defendant is ordered to cease all rent collection activities immediately and refund all lease payments totaling $4,200 collected under the invalid agreement. Furthermore, this court finds that the defendant's actions constitute financial exploitation of an elderly family member under state elder abuse statutes. This matter will be referred to Adult Protective Services for additional investigation. The judge used the word exploitation. Mrs. Eleanor Hayes is restored to her full rights as property owner. The defendant has no landlord authority and no property management authorization. Any future attempts to collect rent or exercise eviction procedures will constitute contempt of this court's order. Judge Williams addressed Jessica directly for her final ruling. Miss Hayes, taking advantage of an elderly family member's desire to maintain family relationships is both morally reprehensible and legally actionable. This court will not tolerate systematic exploitation disguised as household management. The gavel came down at 2:47 p.m. on Tuesday afternoon. I had my house back. More importantly, I had my dignity back. The week following the court ruling brought immediate and dramatic changes to my household dynamics. Jessica stopped collecting rent, stopped issuing property management communications, and stopped presenting herself as my landlord. The transformation was complete and permanent. She also stopped talking to me directly about anything beyond basic household necessities. Good morning, Eleanor. Good morning. The mail is on the kitchen counter. Thank you. our conversations became minimal and formal. Jessica retreated into polite distance, treating me with the careful respect she might show a stranger whose home she was visiting rather than the casual dismissiveness she'd developed over 2 years of controlling my living situation. My son struggled more obviously with the new family dynamic. The court proceedings had forced him to confront his role in supporting Jessica's exploitation scheme. He'd chosen his wife over his mother publicly, and the legal outcome had proven his choice wrong. He approached me 3 days after the hearing with an awkward apology. "Mom, I want you to know that I didn't understand how the lease arrangement was affecting you." "What did you think it was doing?" "I thought it was helping everyone organize household responsibilities more fairly. By charging me rent to live in my own house? I thought you agreed it made sense financially." "David, I never agreed to become a tenant in the home I've owned for 43 years. He had no adequate response to that basic fact. Our relationship required rebuilding from a foundation of trust that Jessica's scheme had damaged. My son had supported his wife's systematic exploitation of his mother. That betrayal couldn't be undone with a simple apology, but we could establish new boundaries going forward. I made it clear that Jessica and David were welcome to continue living in my home under clearly defined terms. No rent payments in either direction. No property management authority claims. No household meetings with voting procedures. No formal agreements beyond basic respect for each other's space and privacy. This is my house. You're my guests. Guests don't manage their host's property or finances. David agreed to the new arrangement. Jessica said nothing but nodded when I outlined the boundaries. I also reclaimed practical control of my home immediately. The first step was changing all the locks that Jessica had upgraded for security purposes over the past 2 years. A locksmith arrived the following Monday morning to replace every door lock, window lock, and garage door code. I watched him install new deadbolts and received all keys personally. No copies for household distribution, no shared access codes. I changed the locks myself this time. The symbolic importance wasn't lost on anyone. For 2 years, Jessica had controlled access to my own home. Now I was the only person with unrestricted entry to my property. My mail delivery reverted to my direct control. Bank statements, insurance correspondence, and medical information no longer required Jessica's review and approval. I reinstated paperless billing for accounts she'd changed to paper statements for easier monitoring. Financial independence felt liberating after months of having my spending patterns scrutinized and regulated by someone living in my house rent-free. I also restored my social connections that Jessica had gradually limited through her guest policy requirements and scheduling restrictions. My sister resumed her Thursday afternoon visits without advance written notice. My book club friends could call and stop by spontaneously, as they'd done for years before Jessica implemented household management protocols. Most importantly, I established clear communication that the legal victory wasn't about punishment or revenge. The court action had been necessary to stop exploitation and restore proper relationships, but I harbored no ongoing resentment toward Jessica or David. We can move forward as family if everyone understands and respects the basic fact that this is my home and these are my decisions to make about my property and my life. Both Jessica and David indicated they understood and accepted the new arrangement. The household settled into a peaceful routine over the following weeks. Jessica focused on finding employment and planning their eventual move to independent housing. David resumed helping with yard work and household maintenance as a son rather than as a property management subordinate. We established a new normal based on mutual respect rather than systematic manipulation. For the first time in 2 years, I felt completely comfortable in my own home. No rent payments due, no lease violations to avoid, no property manager approval required for my daily decisions. I was no longer a tenant. I was the homeowner I'd always been. That was 18 months ago. Jessica and David moved out 6 months after the court ruling to a rental apartment across town. Our relationship remains cordial but distant. Family dinners happen monthly at neutral restaurants rather than in my home. The restitution payment of $4,200 went directly into a new savings account that only I control. Money I'd never expected to see again, returned through legal process rather than family goodwill. My house feels like mine again in every meaningful way. I wake up in the morning without checking rent payment due dates or household policy calendars. I watch television after 10 p.m. without worrying about lease violations. I invite friends over without requesting advance approval from self-appointed property managers. The quiet is peaceful rather than controlled. Adult Protective Services closed their investigation after determining that the court ruling had addressed the financial exploitation adequately. No criminal charges were filed, which felt appropriate for a family matter resolved through civil proceedings. I learned that standing up for yourself doesn't require being harsh or vengeful. Sometimes it just requires being clear about what's acceptable and what isn't. Legal boundaries can restore relationships rather than destroy them. Jessica never acknowledged that she'd done anything wrong, but she also never attempted to resume property management authority over my home. The court ruling established reality more effectively than family conversations ever could. My advice for anyone facing similar situations is simple. Document everything, seek professional guidance early, and remember that you don't owe anyone the right to exploit you, even family members who claim they're helping, especially family members who claim they're helping. If someone in your family has ever made you feel like a stranger in your own home, please don't brush it off as drama. Save this story, share it, because the people who prey on elders count on silence, confusion, and shame to do their work for them. And if you're living this right now, document everything, tell one trusted person today, and get professional help before you sign anything. You don't have to win by yelling. You win by proving it.